Sir, we will speak of challenges to criminal, future challenges to criminal. Thank you.
Thank you very much. It's such a pleasure coming here, speaking before such a wonderful audience, and of course, to speak before an esteemed senior of my profession, Mr. Luthra, who's more like my brother, and Madhvi, who's a great friend. It's also wonderful to speak in front of them. And of course, to speak about criminal law, for Justice Luthra is taking, as they say, hold to Newcastle. But I thought that, I would rather, without addressing the nitty-gritties of it, because there can't be a better person than Mr. Luthra to address the nitty-gritties of it, I'll address some of the broad questions and challenges which I perceive, which criminal law in India and the IPC faces today. Of course, I'll just mark out what the challenges are and why we need to see as to how criminal law in future grows in India, because because we've had the criminal law has been with us for a very long period of time. It's a British code formulated by the British in a specific context when they were during the time of Jeremy Bentham and Fitzjames Stephens, when they actually Macaulay, when they actually thought that they could formulate. The thinking behind that was, as all of us know, was utilitarian, and they thought that they could formulate a code which would be universally applicable across all countries. And not only will it be universally applicable across all countries, but it will also be universally applicable across all time. So it was for time immemorial, as well as it was cutting across countries. Now, as we all know this, that it was applied to various different countries. It was applied to parts of Africa, it was applied to the strait settlements, that's in Malaysia, and parts of Indonesia when it was under British rule. It was applied in Singapore, it was applied in Hong Kong, and applied in India, and Pakistan, and Bangladesh, and Sri Lanka. So it was also applied in the West Indies, in Jamaica, before they came up with the law of their own. So there was this entire formulation that the Indian Penal Code was the definitive common law principles on criminal law which had been codified so that it could be applied across universally to every part of the globe, irrespective of the culture which it came from, irrespective of the economic background which it came from. So as all of us also know that there was this huge discussion which went on at the time of the formation of the code as to how should we go about doing it. There was this school which said that common law, which, as you all know, there was an attempt to apply the code in England, back in the home countries, which was formulated, and it failed. It wasn't allowed. There was a lot of debate, and they refused to implement the code. There was this entire discussion as to whether common law could be applied across the board to different cultures. And there was some even said that the Indian Penal Code was formulated in such a way that it made too much leeway for Indian sentiments. But there was a lot of back and forth on this, and I'll address this question towards the end as to what does it mean towards all of us, and why I personally think that we need to localize the law much more. The first part which I will address is, the broad challenges which I see for the Indian Penal Code can be divided into two parts. One is the globalization challenge, and the other is the localization challenge. The globalization challenge is because these are things which we can see all across, and these are challenges which the code has to take into account, criminal law has to take into account, because this is the challenge which comes out of technology. Whether we like it or not, whether we prefer it or not, the world is becoming smaller and smaller. We are all on the internet. We all have, whether some of us like it or not, having genetically modified products in various different forms, whether we get it in the supermarket, whether we get it in the market, even though the government has tried its best to keep them out, but they're available in some form or the other. There is technology being used on the internet, there is hacking attacks, there is the dark web where all sorts of strange things happen. So there is a genuine concern about the way technology is progressing all over the world. Now, how do you address this concern? Now, does the criminal law in India address it? I would say that the Indian Penal Code, we all know, has been supplemented by other laws to sort of cover up this lacune. But I would say the Indian Penal Code needs to evolve and needs to evolve broader principles, because there are certain areas which it still does not cover today and where it needs to cover up. I'll take the broad examples on some of the more important issues on both internet, IT as well as biotech. One is hacking, which we all know, which is very much in the news with WannaCry and all that. There is people are being held to ransom. How do you handle that? All your accounts are being frozen. You are being asked to pay up till your accounts will be defrozen. How decrypted and how do you address that? That's a question. The law needs to evolve, take up to keep up with that. The other thing is biopiracy. We know a lot of genetic material are being smuggled out of the country. It's being smuggled out, replicated, used by corporate. These are genetic information which are being used, like for example, genetic information is being collected unknown to people, which are then being used for purposes in the lab to make commercial use of them. So again, this is all biopiracy. So how do we handle this? Because this is in some ways it will be theft unknown to knowledge, but what is the worth of a gene? It may be nothing to us, it may be unknown to us, but it may be of great commercial worth in the future. The entire question of identity theft is again a huge question which ties up with Aadhaar, which ties up with a lot of things. Now we live in a world where, as when people talk about Aadhaar and surveillance, I remember once seeing a documentary which said that we voluntarily in today's world give up all our information that we have on the net. On Facebook, it's like we voluntarily post all our pictures, we voluntarily post all our information, put our photographs of our parents, our friends, our children, everything on the net. I was reading and I was watching a documentary which said that at the height of the Cold War in Germany, the penetration of Stasi, I don't know how many of you know, Stasi was...
Marcus was founded Stasi.
The Stasi was this German secret service police, secret police in East Germany. And the penetration of Stasi at the height of the Cold War was 50% of the population, which was supposed to be stunning, fantastic, and they knew exactly what was going on in the country. But they were saying that that's Facebook in certain European countries had a penetration of 70% of the population. So for 70% of the population could be traced. So this entire question of identity theft and what you do with identity and are things being leaked out. We know what has happened in a collection of, I don't know how many of you know the Edward Snowden matter, what happened. And the allegation is that certain intelligence agencies had a program where they could collect information about everyone, infinitely. And as someone said, the name of the program was Boundless Informant. As someone said, it reminded someone for James Bond movie, because James Bond, the villain, has a program or a machine which has names like this, Boundless Informant. So it reminded one, but it's like science fiction actually come to life. So how do you deal with this? Because this is something which we will face more and more in the future, because not only will governments be doing this, but corporates, which has the power to do these things, will do it. Now, how do you handle internet extortion? How do you handle manufacturing and using of biological weapons, or for that matter, biological entities as weapons? These are things which we have to deal with, and I don't know whether we adequately deal with them. Now, the next question is, how do we use cloning technology? Cloning technology is all over the world, and this is the next big thing where People are even saying that you will have your organs farmed. There will be farming of organs. How do you handle these questions? These are both ethical questions, moral questions, as well as questions which criminal law will have to face. Another production of dangerous foods and goods. Because goods which will be produced by biotechnology in the future, some of the foodstuff which are going to be produced, which will be genetically modified, which may have health effects, which you eat, which you grow. The tomatoes, which all of us know, there are some genetically modified products with strange genes inserted into them, but which you may have liability later on, because after you eat them, there may be repercussions at a later point in time. How do you hold people responsible? There are dangerous aspects of the net, and how do you control the dark, and most importantly, how do you control the dark underside of the net, which contains every form of violence, every form of perversity, every form of depravity, and danger of terrorist organizations. Everybody's involved in that. How do you police the net? These are questions which effectively, I don't think our criminal law has been able to come up with a solution. Our solution has been largely a police solution, which has only talked about that if there is a crime committed, then we will punish you. But then our police system still remains in the old world. So with a 17th century, 18th century police system and 21st century challenges, with a law which is somewhere between the 20th century and the 21st century, I don't know how. It's a difficult proposition. I think so we need large-scale reform both in terms of the police as well as in terms of the law. Last part, the second part of sort of my presentation before you is beyond the globalization, the criminal law which we have today is also the problem of localization. And this is something which we know every day, all of us who sort of practice or address criminal law, we know that this is a problem which you face, which is how to make criminal law relevant to people. Because how to change, the broad question is how to change administration-based colonial system. Because, and this is a question which I flag marked right at the beginning, and which I will address now, it almost seems that the criminal law system which you have today is a product of the British Raj. And because it's a product of the British Raj, it internalizes certain perceptions and certain assumptions which come within colonialism. It is paternalistic. It wants to it believes that the only benefit which the people can get comes from the state. And it believes that only state authorities are best positioned to change the behavior of the people. And this is the question which we face, which we face with policing, which we face with justice delivery system. Now, I can say I work as the Attorney General of Nagaland, and you'd be surprised to know in Nagaland, the CRPC, the IPC, none of which is not applicable. There is what is called the spirit of CPC. The spirit of IPC is applicable because most of Nagaland, including criminal law, is governed by tribal courts. And tribal courts mean every court. There are tribal courts, designated tribal courts, and every village sort of addresses its own criminal problems. Now, how does it do that? It sorts out the own problems through largely discussing it within the tribe, within the village. And I can assure you, and friends of mine have gone, there is very little work in the courts. And this discussion I had, a very interesting discussion, and with the the law secretary of Nagaland, when I had just come, I was quite unaware of how the system functioned. So I said, then, what is this tribal courts? And so he said, it happened once. So he gave me an example. He said, once High Court judge, now I don't know whether you know, Nagaland has a bench at the Guwahati High Court. So that means there are people from Guwahati who have never been to the tribal areas, who come to the tribal areas also as judges to preside over the bench. So once a judge came from the Guwahati High Court, and a tribal court had passed an order, and it was placed before him, and it was unusually challenged before the court. It was unusually challenged. Usually there is no challenge to the order which the village passes, but this was challenged before the court. And the judge thought that this is a strange order. Who is the village? And how dare it stop anyone's and passed an injunction stopping him, staying the order of the village. Hell broke loose. The complete hell broke loose. Then the judge was completely scared. He said, why are people going out on the streets agitating? I just stayed a order of the tribal apex body of the tribe. Why are that is not even a recognized organization. So the judge called the law secretary and said, Mr. So-and-so, this law, tell me one thing, what is the worth of this law? So he said, nothing, there is no constitutional validity of this law. So I said, fine, but tell me this, if you were subject to this decision, what would you do? He said, sir, I know, and he's an IAS officer, law secretary. He said, sir, if I was in the position, I would not appeal against that. So that's the reality. And believe me, there is very little criminal matters. So I'm just saying that there is, we are used to this rule of law system. We're used to policing through rule of law. We are used to policing criminal justice in the rule of law, civil disputes in the rule of law, common law framework. But it is possible to have a system outside it. And it works. And I'm not saying it works well, it has its angularities. I'm not a person who would say it works perfectly. What happens to women is a question. There are women who say that they are treated badly because it's male dominated, so they don't get enough justice. That's a question. What happens to small tribes within the larger tribes, small groups within the larger tribes? They say that they are discriminated against. That's a question. And law is supposedly equally applicable to everyone. These are questions. But nonetheless, I can tell you there is very little work, criminal work in the state of Nagaland. And because everything gets sorted out within the villages, everything gets sorted out and people know, and because there's a huge amount of social pressure all the time. So I'm saying that maybe, and most importantly, this is what Mahatma Gandhi spoke about also, that Gram Nyaya, you have devolved the power of doing criminal justice to the villages. The entire question is, we have a halfway house in some places where we experimented with it, but Gram Nyaya only decides on small, insignificant issues, and larger issues are decided by the courts. But these are questions which also go to the root of what sort of jurisprudence that we want. Whether we want a common law-based, international, universal jurisprudence, or whether we want an Indian, Bharatiya, Indian jurisprudence which talks of solving the matters from within the community. Now, of course, the law as we see it today, was given to us by people in a context, was given to us by the British in a very colonial context. They believed, and all of us knew, that they believed that the magistrate who was then, or the district judge who was then British, knew all the answers. And that is why under the procedure, you would see that the magistrate or the district judge is extremely powerful. Session judge is extremely powerful. And even the code, I don't know, Mr. Luthra would be better to say that there is a huge amount of discretion as to, punishment-wise, as to even classifying what sort of crime is being committed on the judge. But that comes from a background that it's usually the white man who was, and I'm not running them down, it was a product of its times, and they were trying to bring law to be uncivilized. So they believed that the white man sitting in a jungle, in a distant corner of the world, was the sole repository of reason, and they could change behavior, they could change civilization, they could govern, because they were the source of knowledge. But the world has changed. So how do we incorporate this and bring in restrictions to make the law more responsive to the needs of the people? These are things which we have to look at. Now, we all know, I don't want to go into details of the IPC, but it does mean that the IPC also needs to be reformulated. One of the issues which have been largely discussed is the evidentiary burden on rape, and the definition of adultery, and so many other stuff, which is a product of the time when it was framed. But most importantly, I think it is time that we bring in Indian conceptions of jurisprudence into criminal law to make it effective, to make it workable, and to make it more relevant to the culture of our people. We make it more accessible, and writing criminal law, at least pronouncing judgments at the trial court level, in the local language, across India, I think would be a good start. I think we need right across reformulation of how we see the accused, how we see the role of the society, how we see the role of the state in all these aspects. Lastly, my submission in summary is, we all know that the Indian Penal Code, the Criminal Procedure Code, has served a great purpose. But it is time, after 70 years, to see whether we can Indianize it, to make it more relevant to the Indian society, to make it more workable to the Indian society, and also, on the other hand, not forgetting that the world is getting smaller and smaller, so we cannot disregard the challenges that we face in the future. Thank you very much.